The Junior Warden's lecture always presents a particular challenge insofar as the reputation of the Junior Warden is concerned. Am I before an audience or a jury? I'm inclined to the opinion that as engineers you are probably all judges. So what follows is the evidence, if this is a trial. The first step in planning my lecture was a look back over my career. It was quite a nostalgic intellectual journey, but it provided me with some of the supporting evidence for the views I espouse today on the matter of enemies of innovation. One of the biggest current questions for the UK is how we will continue to attract investment and outperform our global competitors in cornering a higher proportion of the global wealth relative to our size. We know that answering this question correctly is necessary for our security, for improving the standard of living for our citizens and providing the public services that we all rely upon. However, the challenge is colossal. We are out of the EU. The UK has to adjust to different trading terms in the global market. The global economy has been set back by the COVID-19 pandemic. The UK manufacturing base is only 12% of GDP, and our infrastructure needs renewal. The answer to this challenge, some would say, is innovation, and I would agree. But what is innovation? I'm happy to adopt the definition from the government's recent white paper. Innovation, the development of new ideas, new ways of doing things, new products and services, new technologies and new business models. Or more simply, innovation is the application of knowledge to the production of goods and services. It can be expressed arithmetically as innovation equals invention plus satisfying an unmet need plus route to market. Our government identified the challenges and opportunities by what it has called the Fourth Industrial Revolution in its recent white paper. In fact, the need for innovation is not a choice. It is an imperative. In other words, it is a call to arms for engineers. But innovation does not just happen because money and resources are thrown at it. The enemies of innovation are everywhere and not to be underestimated. So, for the purposes of clarification, from the sidelines as a civil engineer and solicitor, with 45 years experience in the rough and tumble of construction engineering and the law, this lecture is my personal view on the enemies of innovation.
Da-da-dit, da-da-da, da-da-da, da-did-it.
I can hazard a guess that many of you immediately connected with these opening credits and that you were influenced by the BBC's Tomorrow's World presented by Raymond back in the 60s. It was a programme dedicated to innovation and during its 38 years featured more than 7,000 gizmos, gadgets, ideas and discoveries. Many innovations were shown to the public which were hugely successful, including breathalyzers, digital watches and barcode readers. Of course, not all innovations are successful, and that underlines the risk of embarking upon innovation. But on the other hand, not to innovate is to become the victim of a competitor's progress. Many engineers will not think of themselves as having been involved in innovation, but in fact many of us will have been involved in finding solutions to generic or specific problems. Engineers at heart are essentially innovators. The dichotomy of the UK's approach to R&D is epitomised by the perceived need for technological advancement to be big, sexy and expensive. David Edgerton, a leading historian associated with science, technology and medicine at King's College London, argues that the lure of big innovation leads all too often to misguided and wasteful ambition. Thus, ever since the invention of the wheel, nearly 6,000 years ago, man has built civilizations upon its continuing development, so that today we have pneumatic tyres and awesome alloys. To be world-beating, you have only to make tiny improvements to achieve marginal gains. We know this from the huge success of the GB cycling team, where 1% performance improvements led to Olympic gold. Now, looking back on my first steps into innovation, I've been involved in or instrumental in engineering innovation as varied as soil testing, cement technology, ceramics, delivery scheduling, energy from waste, and automobile lamps. In the law, I have exploited the procedural innovations that you may be familiar with, including private finance initiative, mediation, adjudication, and the very exotic terminology for questioning expert witnesses called hot tubbing. But my first involvement with engineering innovation was working on the geometry of a new design for a concrete tunnel lining that could be used as a bolted or expanded section. The benefits to the economics of tunnelling were enormous by avoiding the need to use cast iron bolted segments together with expanded concrete segments for differing ground conditions. In many ways, this example is unremarkable. It was simply a case of a few engineers thinking of an innovative solution. It did not require a massive investment, but could self-evidently reduce tunnelling costs. It was an incremental step in combining the principles of two different types of tunnelling segments. It was not that risky. Innovation becomes riskier when the incremental steps become strides and push the envelope beyond the limits of prudence. By contrast, there was a tunnelling technique known as the New Austrian tunnelling method that had been developed for tunnelling in rock. The method entails spraying wet concrete onto the exposed surface of the tunnel, and this is for protecting the surface as well as resisting the external stresses. It was a very attractive method of tunnelling because it was quick and efficient. However, the tunnelling method came under scrutiny when the tunnels on the Heathrow Express collapsed in October 1994. The contractors were fined £1.7 million for breach of health and safety legislation, and yet no one had been killed or injured. The cause of the failure was put down to workmanship. But the standards of workmanship required, as compared with tunnelling in rock, would have been very different. The risks associated with workmanship need close monitoring to control excessive settlement in sedimentary ground conditions, quite different from hard rock. Pushing construction techniques to their limit and beyond is hardly unknown. I wonder if the engineers ever realised that what was being undertaken was in fact an application that by its very nature was innovative. Many of you will have seen some of those clips of the Tacoma Narrows suspension bridge, responding to wind loading that caused the oscillation of the entire deck structure until its eventual collapse back in 1940. Wind loading was the cause of the collapse of the Elmley Moor Tower in Yorkshire, which at the time was one of the tallest man-made structures in the world, standing at 386 metres. In 1969, the low wind speed, combined with ice load, caused oscillation and collapse. In the inevitable litigation which followed, Lord Scarman, one of the Lords of Appeal, had no truck with the unforeseen consequences of wind speed and ice loading, and I quote, "One who contracts to design an article for a purpose made known to him undertakes that the design is reasonably fit for purpose, provided always there was no provision in the contract to the contrary. The fact is that the law will make no allowances for innovation in pushing construction techniques or design principles to their limits, and this applies equally to products. Engineers can cause great harm, and society's tolerance of harm to its citizens is very different now, as compared with the acceptance of death during the Industrial Revolution and 2 world wars. From the 1950s, there has been huge improvement in life expectancy and standards of living. Imagine the 30,000 deaths from Asian flu in 1957, the 30 to 40,000 deaths from Hong Kong flu in 1968, that these were reported with barely a whimper of criticism by politicians or the press. Since 1974 and the passing of the Health and Safety at Work Act, there has been a slew of legislation to protect the interests of the public, including consumers' health and safety and financial interests. It is therefore all the more remarkable that the mobile phone became widely available in the 1990s. I say this because there was, and to some extent there continues to be, a controversy about the link between cancer and the use of the mobile phone very close to the ear. The cellular phone was launched, as far as I'm aware, without any risk assessment as to the effect of cell phone radio frequency electromagnetic radiation. Since when, the association between cancer and the cellular phones has been the subject of countless studies. The existence of that association has not yet been entirely dismissed today. Bearing in mind the catastrophe of thalidomide, tobacco, and even talcum powder, the ethics of launching the mobile phone could be said to be questionable. If the mobile phone were being launched today, would it have ever be sold without health warnings or guidance as to its use? Engineers have a legal duty and an ethical duty to do no harm. Acting ethically, engineers need to evaluate the potential harm of new products and technology. That evaluation could stop development or certainly delay its introduction until studies to prove the new products and technology are safe. The safety of products comes into sharp focus with the recent litigation history of breast implants. Some recent studies at the Harvard Business School demonstrate the link between an increase in product liability litigation and a commensurate decrease in the number of patent applications. This adds up to a reduction in appetite for innovation, aided and abetted by the insurance companies who pick up the bill for the old technology. So, here is the dilemma. Should we, as a society, find a mechanism to loosen the constraints of the law and regulatory framework to avoid depressing the benefits of innovation? This is a current dilemma in the quest for a COVID-19 vaccine, where European governments have already reached an agreement with AstraZeneca to protect the company over any liabilities stemming from its candidate for a vaccine. The agreement is designed to provide an indemnity for the high risks it takes in the rapid development of the vaccine, although under the arrangement, AstraZeneca will pay legal costs up to a certain threshold. This agreement is to some extent presaged by the government's white paper, Regulation for the Fourth Industrial Revolution, which acknowledges that where businesses face lengthy, costly, complex or uncertain processes to secure regulatory approvals, they are less likely to be able to persuade potential investors or consumers of the merits of their innovation, and less likely to innovate. The government recognises that unless there is a loosening or relaxation of the current law and regulations that would ordinarily cause a negative impact on innovation, some of the most important innovations will never be funded or developed. In addition to the constraints created by regulations, an innovator has to confront the challenge of the standards-making industry. Regulations and standards favour the old technology and the established players. Just to avoid any doubt, standards and codes of practice do not have the force of law as compared with regulations. Earlier in my career, I had been a member of committees and European working parties for the making of industry standards for cement. I was arguing for the blending of pulverised fuel ash from power stations with ordinary Portland cement to make a superior product. The cement manufacturers fought tooth and nail to prevent the publication of a standard that would allow more than 5% of PFA in a cementitious blend, despite all the overwhelming evidence as to the efficacy of the PFA-OPC blend. The fight to have PFA recognised as a component of cement took over 25 years. As a lawyer, I have litigated and argued over cases in respect of surgical gowns and portable buildings that depended upon the precise wording and scope of standards. Standards are an effective means by which established businesses can freeze out competition from superior products. I should point out that the advocates for the established businesses are invariably engineers digging in against innovation. So, if an innovator cannot persuade a standards-making committee to recognise the efficacy of a new product or a variation to an existing product, it creates huge hurdles for getting the new product onto the market. Another hindrance to innovation can be the very instrument used to protect the exploitation of an invention. I am, of course, talking about the patent. We had a highly informative soiree from David Knights, one of our liverymen and who is also a patent solicitor, on the history of patents. The use of patents to protect inventions provides the patent holder with protection for 20 years to exploit the commercial advantage of being first mover. This creates a genuine conundrum. A system designed to increase innovation operates initially by suppressing the adoption and improvement of new patented technologies. The benefit to society is finely balanced, but the evidence one way or the other is not conclusive. But as an aside, Matthew Boulton and James Watt's steam engine patent was litigated, and it suppressed the continuing development of the steam engine until 1800, when the patent expired. In the following years, the output of steam engines increased dramatically as a result of further innovations. However, for the innovator, obtaining an effective patent that will provide the widest possible protection is not inexpensive. It is even more expensive to protect patents by litigation. There is no point in having a patent unless it is worth protecting. Start-up companies and SMEs can be hampered by the costs of patent applications and protection of patents, which has the effect of diverting away cash from the refinement of the invention for commercial exploitation. Many businesses that have relied upon innovation never felt the need for patent protection, and I include in that the worshipful company of clockmakers and the worshipful company of spectacle makers. The number of patent registrations is often used as a metric for how innovative a business might be, but this can be a misleading guide. It is only inventions that can be protected by patent, but patents are not the only means of protecting intellectual property rights. The recipes for McVitie's biscuits and Coca-Cola have remained confidential to this day, thus demonstrating how effective confidentiality and non-disclosure agreements can be. However, the cost of infringing patents, even for big business, should cause a board and its investors to take stock when court awards can be very many millions of pounds. Patent litigation keeps 10 dedicated High Court judges very busy. Even employees can be entitled to damages, as in the Supreme Court decision earlier this year in the case of Shanks v Unilever. An employee of Unilever was awarded £2 million by the Supreme Court for an outstanding benefit his inventions bestowed on Unilever. Now, talking of confidentiality, we have to consider employees. We can all accept that innovation is a human endeavour, but therein lies an immediate challenge. Humans are capricious, devious, deceitful and dishonest in the pursuit of self-interest. And after 30 years of practising law, my impression of human behaviour never ceases to improve. The information in an employee's memory cannot be eradicated, but the memory of knowledge is of decreasing value with time. Documents in any medium will be specific, transportable, and potentially very valuable to a competitor. So how can an employer ensure that the singular repository of confidential memories and supporting documents remain confidential? The employee needs to be cloaked with a structure of control and legal gags. This is achieved through an effective contract of employment and management of access to documents. Intellectual capital is often the most valuable asset that a company owns, and yet the means of protecting it are dealt with in a routine, if not cursory fashion. Attention is often devoted to incentivising senior employees with bonuses, share options and career progression, all designed to engender loyalty and create motivation. But such incentives are not always effective if a bigger fish offering bigger bucks comes along. This is a particular risk for SMEs. The value of a well-drafted employment contract is not to be underestimated. If the value of an employee is properly recognised, it is possible to build in enforceable restrictive covenants and notice periods or gardening leave of over 12 months for the purposes of protecting a legitimate business interest. There are examples where the courts have upheld protection for as long as 2 years. But after 2 years, the knowledge an employee had will have lost a great deal of its currency. In my experience, one of the obvious controls that is often overlooked in the control of access to documents is the tracking that should take account of being downloaded, when it was printed, read or amended. Being able to adduce such evidence is very powerful in an application to obtain an injunction. Over the years, I've obtained injunctions and substantial damages for clients who have been the target of competitors poaching individuals and teams. For an employee who is restrained by a court injunction for breaching an employment contract, it is a sobering realisation that ignoring its terms can lead to imprisonment. Another risk associated with employees is lax IT security, such as passing on passwords or handing over USB sticks. All these things are actually quite commonplace. A more emotive term for the general area of stealing confidential information is industrial espionage. The risk of hacking by competitors, either directly into a company's computer system or tricking employees, is a present and serious threat. I have been involved with many companies that engage specialist hackers whose task it is to penetrate the client's computer systems. In a mercenary world, the friendly hacker should be bound by contract to ensure that the penalties for going over to the dark side are too harsh to even contemplate. Not least, of course, hacking into another person's computer system is a criminal offence. The effort needed to protect confidential information cannot be overestimated. It is a genuine cost and should not be skated over by using standard employment contracts or relying on standard virus software as a defence against cyber attack to steal information. IT policy should be hardwired into a company and incorporated in all employment contracts. One of the most uncomfortable experiences in my professional role as a trusted business advisor has been addressing the disparity in treatment between male and female employees. I have come across gross differences in pay between men and women by as much as 30% for exactly the same professional role. These differences are not commonly found in public service, except perhaps for the BBC, but there are legions of companies where this is the case. The blindness or unwillingness of senior management to address the unfair treatment of women fills the employment tribunals with claims for equal pay and other unfair treatment. Even where I have pointed out the iniquity and the legislation demanding that women are treated equally, it has sometimes fallen on deaf ears. The engineering profession knows that women are underrepresented within its ranks, and the lack of women in engineering has nothing to do with academic ability or lack of hard work. As females pass each academic milestone from GCSEs to degrees, there is a pronounced decrease in the percentage representation of women. And of those women who have engineering degrees, many do not stay in engineering. Why women don't always receive equal pay or choose engineering as a career is beyond the scope of my lecture, but it has everything to do with innovation. It is well documented that diversity in the workplace bestows a positive benefit on an organisation's innovative capability that provides a commercial advantage. Disruptive innovation is well served by diversity. Just consider human-centred design and design thinking, whereas homogeneity breeds a more derivative approach. Disruption is game-changing, hence progressive. In its briefing paper entitled Gender Disparity in Engineering, published by Engineering UK in 2018, it said, "Research has consistently shown that a more diverse talent pool brings with it increased creativity and new ideas, as well as enhanced motivation, retention, group solving problems and financial performance." McKinsey have estimated that bridging the UK gender gap in work has the potential to add £150 billion to GDP by 2025. That's barely 4 years away. But alongside gender issues, which is just one facet of diversity, we have a tendency in engineering to overlook the underrepresentation of ethnic minorities. In 2019, the ONS data shows that 14.9% of science, engineering and technical professionals had an ethnic background. This figure is comparable to the number of women in engineering, even though in the percentage of 14.9% there will be women who are effectively double counted. The Federation of Small Businesses commissioned some research from the University of Aston to assess the value of ethnic minority businesses, or EMBs, to UK activity and enterprise. The report is entitled Unlocking Opportunity. It concluded that 30% of EMBs had recent product or service innovation, as compared with only 19% of non-EMB counterparts. There are approximately 250,000 EMBs, and they contributed £25 billion to the UK economy in 2018. But worryingly, they face barriers to growth, despite the fact that they are more innovative and more likely to export, particularly to Commonwealth countries. Diversity also includes diversity of acquired experience, which is just as important and influential. Candidates for jobs should not be overlooked because their profile does not fit the stereotype. Unusual or unconventional areas of study, different industry background, and foreign work experience can add to the competitive edge. The Wall Street Journal examined diversity and inclusion among Standard & Poor's 500 for a thought leadership article last year entitled The Business Case for More Diversity. It concluded that diverse and inclusive cultures are providing companies with a competitive edge over their peers. Forbes followed up with an article on how diversity boosts innovation and financial results. The best companies attract the best candidates. Only 12 of the Sunday Times best companies to work for in 2020 came within the category of engineering, construction or digital technology. The engineering sector shows up poorly, by omission. My own firm has been ranked 50th in its best year. The status of being in the top 100 is taken very seriously because we know that it attracts outstanding applicants and is demonstrably inclusive. UK law has provided a framework for treating all employees and members of society fairly and equally, to create and promote inclusiveness since the 1970 Equal Pay Act. All the subsequent legislation was consolidated into the Equality Act 2010. It is clear to me that the senior management of engineering companies must try harder. Next topic is the relationship between investors and senior management. I've linked these together because these are the very persons or organisations who you would think should embrace innovation, and that their relationship should be aligned on the same goals. However, there is plenty of evidence pointing to the opposite, because senior management and investors are persuaded that the risks of innovation are a threat to the business. On the other hand, the risk of doing nothing is certain failure. I've noticed that the Oil and Gas Technology Centre states on its website the following. Whilst market and organisational factors can impact adoption, it is the psychological barriers that are the strongest and the least understood. It's for that reason that the OGTC has a study underway to identify the key psychological factors that influence the deployment of new technology and tools in the oil and gas industry. It's interesting to note that they identify different industries as more successful innovators, such as retail and automotive. Investors, particularly founding investors, can run into difficulties especially where a product has been successful and there are further rounds of funding. Either the investor has to accept being diluted, or, as in a recent case of mine, the fact of dilution was litigated and threatened to hold up a public placing on the stock exchange. Arguments between the board and investors burns up cash and deflects the efforts to achieve the best result from the innovation that everyone had been focusing upon. To achieve success in commercializing innovations and new products in startups, family businesses and SMEs, it requires for there to be a commitment and focus on the prize. Disputes can be avoided by well-drafted shareholder agreements and an unswerving belief in the need for innovation. Finally, I come to government as an enemy of innovation. Largely in response to the challenge of Brexit, the government has issued a number of white papers which set out its undoubted commitment to R&D and innovation. The plans are ambitious, with the UK investment in R&D planned to be 2.4% of GDP by 2027. The House of Commons Science and Technology Committee looked at the balance and effectiveness of research and innovation in spending and published its report entitled Balance and Effectiveness of Research and Innovation Spending in September last year. One of the standout issues for me was the evidence of the Association of Innovation, Research and Technology Organisations. That the UK had generally a ratio of 10-1 between science funding and innovation funding, as compared to ratios of up to 1-1 in other competitor nations. The suggestion that the Industrial Strategy Challenge Fund may have helped to narrow the gap is not something I can comment upon, but 10-1 versus 1-1 science to innovation is unfathomable. But what I can say is that over 4 days of oral evidence and 90 submissions of written evidence to the committee, only 2 submissions were from industry, notably BAE and Rolls-Royce. As an outsider, it looks as though science policy is being driven by those organisations and individuals who will benefit directly from the government's largesse. To what extent does the Science and Technology Committee reach out to industry? The apparent influence on science policy by industry scarcely moves the dial. There are innumerable numbers of SMEs that have ideas to make money from innovation, but suffer from being unable to access the state's R&D coffers, either to initiate an innovation or because they need top-up funding. There are a large number of different science and engineering organisations that are involved in policy, advising and funding. It is an impenetrable tangle of different organisations that all have slightly different criteria for funding, and many of them have a common parentage. How do we communicate with SMEs to encourage applications for innovation funding? I don't know, despite the government's attempts. But what I do know is that there are over 5.9 million private businesses in the UK at the start of 2019, and more than 99% of those are small or medium-sized businesses. There are too many SMEs, many with great ideas, who scrabble around for private funding, who should be capable of being pointed in the direction of one address for an application for R&D or innovation funding. So, to summarise, the enemies of innovation I have identified are pushing a technology too far without appreciating its limitations. 2. The need to apply an ethical approach to projects or product development, especially health and safety issues that may stall progress or even need to be abandoned. 3. Regulations that can cause delay or stop innovation. 4. The making of industry standards that favour the established players and the old technology. 5. The cost of obtaining or enforcing patents, plus the more general effect on depressing innovation generally. 6. The behaviour of employees. 7. The lack of a diverse workforce. 8. Attitudes of senior management and investors. And finally, government policy that is exceptionally biased towards basic research at the expense of innovation. So, my closing remarks. In a recent and very illuminating book, How Innovation Works, the author concludes, most innovation is a gradual process. The modern obsession with disruptive innovation is misleading. Even when a new technology does upend an old one, the effect begins very slowly, gathers pace gradually, and works by increment, not leaps and bounds. Innovation often disappoints in its early years, only to exceed expectations once it gets going. I have called this lecture Enemies of Innovation. And to overcome enemies, you need heroes, or even the superheroes that my grandchildren tell me about. Those heroes will, within a corporate structure, they'll be able to cooperate, create, coordinate and contribute to make innovation a success. Heroes are the team members, including the engineers. But I hope you will appreciate that one of the heroes needed to build the defences and sometimes lead the attack against the enemies of innovation is an indispensable engineering-educated lawyer. Thank you very much.